welcome to Think Tech Global. I'm Jay Fidel. We are honored today to have Ben Wizner with us, and he's in the J term at the law school and teaching up there, I guess. We'll find out more about that. Ben Wizner is the director of ACLU's Speech, Privacy, and Technology Project. For nearly 15 years, he's worked at the intersection of civil liberties and national security, litigating all across involving airport security policies, government watch lists, surveillance practices, targeted killing, and others. So he appears regularly in the global media, including Think Tech. Just put this on your CV.
It's on the list.
He has testified before Congress, and he's an adjunct professor at New York University School of Law, which is my school. Since July of 2013, he has been the principal legal scholar to NSA whistleblower Ed Snowden. He's a graduate of Harvard College and New York University School of Law. That's my school, and I'll mention it again. And was a law clerk to Honorable Stephen Reinhardt of the U.S. Court of Appeals for the Ninth Circuit. Welcome to the show.
Glad to be here, Jay.
Great to have you. So, there's so many things we could discuss because you're counsel for Snowden, but I don't want to ramp up to that. So 15 years ago, you got involved in ACLU kinds of things, government versus citizen, all these issues that arose out of 9/11, and I assume that 9/11 had something to do with that.
Not exactly. Oddly enough, my first day at the ACLU was in the first week of August 2001. And I was pretty sure that I was going to the ACLU to do ordinary civil liberties work. I was working in Los Angeles at the time. Los Angeles County has the biggest jail system in the world that has been under a consent order from an ACLU lawsuit, and I was going to be, poking around in the jails. Now, it turns out 9/11 happens a few weeks later, and LA jails becomes Guantanamo, becomes CIA black sites around the world. So if you had told me when I was in law school that I would be working on issues of torture, I would have thought, oh, how interesting, I'm going to be an international human rights lawyer working, somewhere in the Middle East or in Africa. It never occurred to me when I was studying law that I could work on the issues that I've worked on because of the actions of my own government.
Now, your family is involved in law. Your father is a professor at Yale, and he does the clinical program up there. What effect did that have on you in terms of selecting and staying with this topic?
Yeah, that's right. I mean, he calls himself a glorified legal services lawyer. And what that means is that clinical law means that instead of teaching law theoretical, you teach law as practice, and you do it largely by representing poor people. And so Yale law students are able to work with him and actually provide legal services to people who would not otherwise get them. And so I grew up in an environment where practicing law to me was, to see these idealistic law students who were going into the lowest courts in America and using their power and privilege on behalf of people who had none. So that was, certainly a model of what a meaningful life could be.
Great background, really gets you involved in the practice, but also in the policy around that.
Sure.
So, oh, by the way, if you want to tweet, if you have a question for Ben Wizner, send it to us at ThinkTechHI. And he has a Twitter account also. What is that?
It's really just my name. It's at Ben Wizner.
Okay. Of course, we won't see that, but we'll see it if you send it to ThinkTechHI. Okay, so, after 9/11, seems like, to me, we the country, went further than we needed. And maybe this is just retrospective, but we were really irritated at what happened in 9/11, and everybody was, angry and trying to find a way to stop those guys from ever doing it again, never again. And so we made the Patriot Act 1 and 2, and we took some draconian steps. Did we go too far?
Of course.
Sorry.
Of course we did, and this isn't the first time in our history that we've done so in response to a threat, real or perceived. Obviously, an example that's emotional to people here in Hawaii is the World War II internment of 120,000 Americans of Japanese descent, but you can go back to the 18th century with the Alien and Sedition Act, which was aimed at French sympathizers. You can go to the Civil War, where the great President Lincoln suspended habeas corpus. During World War I, you had people who were against the war being imprisoned by Woodrow Wilson's administration, and afterwards, Attorney General A. Mitchell Palmer rounding up and deporting thousands of people, after which the ACLU was founded. During the Cold War, of course, we had McCarthyism. This is a common strain in the history of this country, that when there is fear, we tend to set our values aside. Now, the good news is that we almost always realize that at some point, and the pendulum swings back. So the examples that I just gave you are considered by everyone in the country who's not running for president on the Republican ticket to have been historic errors. And so my worry about the post-9/11 environment, although we'll get to Snowden in a minute, is that in all of those other instances, the threat as we understood it ended. We moved on. The war ended. We might not have known when World War II was going to end, but we knew how. There was going to be a surrender ceremony somewhere. How is this war going to end? When is it going to end? When we define an armed conflict against terrorism or a terrorist group, who's going to decide that it's over? And so will these compromises that we made, that historically have been short-term compromises, begin to seem more permanent? That's what I would have told you before 2013. I think that the Snowden revelations have helped to swing the pendulum back towards rights and liberties, but I don't want to jump the gun on your questions.
Yeah, no, and I was going to ask you, in general, and it's hard to answer this, I think, how long does it take to swing the pendulum back?
Yeah, I mean, I think that ordinarily, the immediate threat or conflict ends or recedes, and then there is some kind of reappraisal evaluation of whether the policies were the appropriate ones. With 9/11, it took a little bit more than a decade for us to really begin that in a serious way. Before that, we had the Supreme Court stepping in a little bit in 2005 and 2006 and slapping down some of the worst things that the Bush administration did, locking up prisoners with no access to lawyers or courts. But I think it really wasn't until Snowden came forward and revealed that the leaders of our national security establishment, whose power is predicated on our trust, had not only withheld critical information from citizens, but had affirmatively lied to us and misled us about what they were doing. And once that trust began to erode properly, all of a sudden we had a different kind of conversation about the balance between rights and security.
Two thoughts on that. One is the other examples you gave over the country's history. Had there been lying, deceit by the government to the people in those cases?
Well, I think so. For example, in the case of the internment, there was information available to Governor Warren in California and to others from intelligence, from the military, even from J. Edgar Hoover, that there was no real threat that justified this kind of action. So there was certainly political opportunism, taking advantage of fear. Certainly in the McCarthy era, there was a huge amount of misrepresentation and dishonesty. So I don't think there's anything particularly new about people who are entrusted with our security lying to the American people. They believe in our best interest.
In the name of security, yeah.
They believe in our best interest. And actually, this is a very important point, because I think if you ask many people who are entrusted with security positions, they would say that protecting the security of the American people is their foremost responsibility. That's actually not quite right in a democracy. They only swear one oath. They don't swear an oath to security. They swear an oath to the Constitution. And when you begin to say that security is so important, that maybe some of these laws seem a little bit quaint, then you have people like J. Edgar Hoover, who was the FBI director for 50 years, who run a secret police that do more that's illegal than legal.
It's doing damage, actually.
Right, absolutely.
So, the other thing I wanted to mention or explore with you is that, since Vietnam, especially since Vietnam, there has been mistrust of the government, and Vietnam created mistrust. There was a PBS special a couple of weeks ago called The 1960s, and wow, there was a lot of distrust, and it didn't go away right away. And so, when 9/11 happened, it was fertile ground for further distrust. Of course, everyone was really angry about 9/11, but it was fertile ground for further distrust. So this came at a time when things hadn't settled down, in my view anyway, from
Yeah,
Vietnam.
I'm not sure I agree. And I think, if anything, there was not nearly enough mistrust after 9/11. The impulse of the people was to come together. You even saw the media falling into line and not doing their job to question why, if the terrorist organization that was responsible for this was being harbored in Afghanistan, are we mobilizing our military to invade Iraq, a secular dictatorship
People let
that is
that
an
happen.
enemy?
Yeah.
And not just people, but people whose obligation, and here I'm talking about the media, is to ensure that the public has enough information to make decisions about war and peace. And you have reporters who have since said, we were scared to question authority at this time. We didn't want to be criticized as being against the administration at a time when it was building a case to go to war. So, no, I think in the context of war and peace, other contexts as well, it is profoundly patriotic to mistrust our government.
You heard it here on Think Tank.
Very dangerous to trust it.
Yeah.
And the Constitution was written by people who knew that government couldn't be trusted. They did their best to divide, to carve up power between different branches that were supposed to be co-equal. We want judges questioning the president. We want Congress questioning the president. We want them to be competing with each other in a sense, not just sort of teaming up or looking the other way as one branch acts in authoritarian ways.
So this is the nature of your practice, this kind of issue, at least since 15 years.
Sure.
And I wonder, how you've had a lot of cases. The Manning case I saw when I read up on you. And
I have actually not been directly involved in the Manning case, but
you've written about it.
But sure, yes.
You've written about it. It's in your blog.
Yeah.
Okay, Ben has a blog. You can look at the blog. It's what Ben.
Well,
Wizner.
it's really the ACLU's blog, and I and many other ACLU lawyers contribute to it periodically.
Okay. It's one of those collective
Yes.
blogs. Sort of like Jack Balkin at the Yale with his Balkanization blog, where he has people contribute from all over the country.
There's just more of us. Yeah.
Okay. Anyway, tell us about the nature of your practice.
Well, I think that what it means to practice constitutional law for an organization like the ACLU is to step in places where politics fail. That's maybe the simplest way of putting it. We're in the middle of a presidential election right now, and an election for Congress as well. And a lot of issues are being debated. What should the country's tax policy be? In general, what should its foreign policy be? For the most part, we want to entrust those kinds of decisions to voters and elected officials. But there are some decisions that the framers of the Constitution did not want to entrust to voters. Remember, it wasn't long ago that large majorities of people in this country supported making it illegal for people to have mixed-race marriages. And it was only in the last year or so that the Supreme Court established marriage equality for same-sex couples. Large majorities in this country might strip away rights from immigrants who can't vote to protect themselves. Large majorities in this country supported segregation in the South. The Bill of Rights is there to protect minorities from majorities, and the job of a constitutional lawyer is to bring those claims to a court to adjudicate them.
Mm-hmm. So those claims have included civil liberties and national security,
Sure.
Cases involving airport security. You've had cases about TSA?
Well, so for example, as you surely know, our government operates something called a no-fly list.
Sure.
And this is not people who just have the inconvenience of being pulled aside, checked again, and then allowed to go through because their name might resemble somebody else's. I'm talking about people who are not allowed to board a plane. They show up at the airport, they're surrounded by law enforcement, they're taken to a room, and they're sent home and not allowed to board. And so the government—
And they never knew about it in advance.
They didn't know about it in advance, and even afterwards, the government won't confirm or deny that they're on a no-fly list, and there's no process where they can confront evidence against them. Say either you have the wrong person or I didn't do what you think I did. There's no trial. It's a completely arbitrary exercise of authority. It's an executive branch official sitting in a room, putting a name into a database, and that's it.
That's scary.
So we brought a lawsuit, obviously saying that, at least with respect to U.S. citizens, the Constitution has something to say about that process, and we've had some success in that. The court agreed that the government couldn't just do that without offering any kind of explanation or any opportunity to challenge the practice. But yes, it's also I have represented victims of the Bush administration's torture policy, both foreign citizens who were essentially kidnapped, rendered, chained to the floors of airplanes, flown off to secret prisons and held there incommunicado, but also American citizens like Jose Padilla, held in a military brig in South Carolina, denied access to counsel for almost 2 years, held in sensory deprivation. And in all of these cases, I was trying to get some recognition, some compensation for the victims for what they had endured, but more than that, to get our legal system to vindicate our values and to vindicate the prohibition on these kinds of things. And the sad news here is that every single lawsuit after 9/11 that was brought by a torture victim was dismissed by the court without any adjudication of either the law or the facts. What I mean by that is that no court looked at the factual allegations and said, we believe this or we don't believe this. No court looked at the legal claims and said, these are right or these are wrong. Every one of those cases was thrown out on what non-lawyers would call technicalities, but what lawyers call the state secrets privilege. This case would harm national security if it went forward. Various immunities. You can't sue me, I'm Donald Rumsfeld, I'm immune from this kind of lawsuit. Or other procedural hurdles to having the case heard. And that, I think, is a tragedy, not just for the torture victims, but for our country.
Whew, it is a tragedy. We're going to take a short break, Ben. We'll be right back. This is Think Tech Global. We're talking to Ben Wizner. We'll be right back.
Aloha, this is Keli'i Akina, president of the Grassroots Institute, and I want to thank you for watching Think Tech Hawaii. We are delighted to be partners with Think Tech because it gives us the opportunity to bring to you a show every week on Monday at 2:00 p.m. called Ehana Kako. Ehana Kako means let's work together because we believe that Hawaii will be a better place when everybody works together. And in what way? Well, at the Grassroots Institute, we research 3 basic areas and we invite guests to come on board from across the country, the state, and the nation to talk about a better economy, a better government, a better society. Now, aren't those things we all want? Indeed. If you'd like to have the latest research in terms of public policy, as well as ways in which we can build a better government, economy, and society, then tune in every Monday on Think Tech Hawaii at 2:00 p.m. for our fascinating guests on Ehana Kako. Let's work together. I'm Keli'i Akina with the Grassroots Institute, and I'll see you then. Aloha.
Okay, this is Think Tech Global. I'm Jay Fidel. We have Ben Wizner, director of the ACLU's Speech, Privacy, and Technology Project, and handling all kinds of remarkable cases that we need to know about. So let's go on to some of the others. How about surveillance practices? What's the government doing, and how can we stop that?
Well, so now we're getting to my most famous client, Mr. Snowden. I think too often the debate over surveillance is argued against straw men. And so you have the government or the intelligence community saying, why are you against surveillance? No one is against surveillance per se, or at least no one who I talk to is against surveillance. The question is, what kind of surveillance should we do, under what legal authorities, and under what kinds of controls? The problem after 9/11 is that the technology far outpaced the democratic controls. Computers were getting more and more sophisticated, storage was getting cheaper and cheaper, and you had a director of the NSA, Keith Alexander, whose mantra was, collect it all, collect it all. Parenthetically, the authorities will follow, the budgets will follow.
That's a technologist's way of looking at it.
That's right.
You collect it all, then you find the technology to search it all, and then you come up with stuff.
The uses will come later, the authority will come later, but for now, we allowed our practices to be dictated by our capabilities rather than constrained by our values and our laws. Yeah. The reason why they built these massive data centers and started collecting as much as they could was because they could, not because they should. And that happens when you have a combination of technological progress and excessive secrecy. Yeah. So they weren't debating this out in the open. And what I would say is that even if you think, as I don't, that we should have a spy agency that tries to collect basically every communication in the world. Why can't we debate that publicly? The NSA is a significant branch of our military. It is acting in our name, purportedly in our best interest. The American people shouldn't be treated like children who can't be told because it's in their best interest to be in the dark. And so the most important thing that Edward Snowden did was not reveal a particular surveillance practice. but to restore democratic participation in a corner of our government that had been too dark.
But the Patriot Act 1 and 2 gave the NSA some cover on that, right? They had some authority under 1 and 2.
Remember that the Patriot Act, which was passed very, very quickly after the 9/11 attacks, the vote in the Senate was 98-1.
Everybody
there was
was
no
afraid.
time to read this 350-page bill. By the way, the Patriot Act wasn't written after 9/11. It was mostly written before. These were authorities that the FBI and others had been seeking for a long time, and it was an opportunity for them to get their wish list. This is what happens in times of crisis. That doesn't make them evil, it makes them opportunistic.
Yeah.
They had long wanted to be able to have relaxed prohibitions on what they could collect and what they could do with it. Now, the problem is not just what the Patriot Act said, but that the NSA and the Bush and Obama administrations interpreted it in a way that went far beyond its actual language. So in Section 215 of the Patriot Act, it says that the NSA and FBI can get records that are relevant to an ongoing terrorist investigation. Well, they interpreted that to mean they could collect all of the metadata from every phone call made by every American every day,
That's
to collect
a
it
stretch.
every day and to store it for 5 years. Now, it's a huge stretch. This was the first document that Mr. Snowden revealed, or that was revealed by the journalists to whom he entrusted the information. 2 years later, in a unanimous federal appellate decision in New York, the first judges to have considered the legality of this in an open legal proceeding.
It had never been tested in court before.
Well, it had been tested in a secret court called the Foreign Intelligence Surveillance Court, where only the government appears. So that court hadn't had the benefit of having anybody say, wait a minute, maybe this isn't constitutional. Maybe Congress didn't even authorize this. The first time we were able to bring this actually into a real open court, because we had the document, the court said in a 100-page opinion that this program is illegal, that Congress didn't even authorize it in the Patriot Act, and it's never been legal. So that, of course, is something that could not have happened if Edward Snowden had not brought the public into the conversation by giving this to the media. So I really think that the most pernicious thing we learned is what happens when there is no public oversight. These programs, many of them are not surviving public scrutiny. And I would posit that government behavior that can't survive public scrutiny in a democracy is illegitimate.
Yeah. The FISA court, was it ever tested? Is it being tested? Is there a case out there that says you can't have, a star chamber here in this country?
Well, in fact, in 2015, Congress passed and the president signed something called the USA Freedom Act. This was the first time since 1978 that Congress had legislated to restrict rather than expand the surveillance authority of the intelligence community. We were talking about pendulums before, so
Yeah.
this was really a historic shift, and part of that bill was to create the possibility for adversarial process in the FISA court. So in cases that go beyond the issuance of simple warrants, but where that court is being asked to interpret a statute or to interpret the Constitution, there are now a handful of designated amici, friends of that court, people who have legal and technical expertise, who can be appointed to represent the interests of the public before that court. We don't know how that's going to work yet. This is a brand new thing, but again, it at least provides the opportunity of having some adversarial legal process in a place where it hadn't existed before.
We are in new times, aren't we? So many things are happening that are new. And I just want to bounce some off you. The whole affair with Ed Snowden, in my view, has changed diplomacy. You can't have a lot of the things that were happening before in diplomacy.
It may, in fact, be more the Chelsea Manning and WikiLeaks case that had that effect on diplomacy. Remember, it was Manning who provided to WikiLeaks those thousands of State Department diplomatic cables that cast a very fascinating light on confidential state-to-state diplomacy. But I think that the new reality is, when Daniel Ellsberg in 1970 wanted to make a copy of the Pentagon Papers, they were thousands of pages locked in a safe in his office, and he had to sneak them out little by little and Xerox them on a Xerox machine. And now you have people like Manning and Snowden, who by pressing a few buttons could put many times that amount of information on a thumb drive or onto a CD-ROM. So even as the government's capabilities are increasing, its vulnerability is also increasing. And if one effect of that is that people in government are more nervous about engaging in behavior that they would not want to see on the front page of a newspaper. I would say that's a positive effect, not a chilling effect.
Security has changed. National security, the way it's conducted at NSA and other places, right? It has changed. We're in a process of change. You can attribute that to Snowden and maybe others, but we're in a dynamic.
Yes, although I think that this is a longer post-war trend. I don't like the term national security. I don't really know what it means. I know what national defense means. But national security is often, I think, a weasel term. It just covers too much. What constitutes national security that would not fall within national defense? I think it ends up being this kind of mantra that gets invoked in order to justify exercises of government power. The reality is that the United States in 2016 is the most secure nation in the history of the planet. And yet we're having a presidential campaign as if we're being invaded on all sides. This is really, really madness. Our government leaders know that citizens are more likely to drown in a bathtub than they are to be killed by a terrorist, but they can't say it. So I think the big problem with security and the conversation around security is that we haven't contextualized the threat of terrorism. We're not talking about massive armies that have nuclear weapons pointed at us as we might have been in the Cold War. We're talking about ragtag bands of people who actually cannot be stopped, right? I mean, if any 2 or 5 people want to grab conventional weapons and are willing to trade their lives for the lives of a few others, as in San Bernardino or worse in Paris, there's not a whole lot that a $50 billion intelligence community can do to stop them. And that's the other thing you don't hear government officials talking about. So the change that I would like to see, if we're talking about change, is that I'd like to see an honest conversation about terrorism and security that acknowledges how strong we are, how weak they are, and how, in some sense, little the government can do to prevent small-scale terrorist attacks.
What can the government do these days? Let's assume that the Snowden case, what he did will be in some way validated, and that the right of the whistleblower will prevail. How does the government actually go on to provide the security that people politically expect?
Yeah, I mean, it's a hard question to answer. I mean, if people expect our government to have a 0 error rate, if every time we have a San Bernardino attack, remember, this is done by a husband and wife. It doesn't matter what kind of NSA surveillance you have. You're not going to get into every conversation in every bedroom between a husband and wife. If people are going to see that as a failure of the national security state, then I don't have a lot of hope for this kind of conversation. Right? Not every time there is a terrorist attack was there a failure. Remember, the dots always connect in hindsight. But back then, there are a billion possibilities for how things might or might not take place. And I think that we need to be acknowledging how fortunate we are. A statistic that I saw, in 2015, there were 26 terrorist attacks around the world that had 50 or more deaths. How many of those were in the United States?
Very few.
How many were in the West? 1. How many in the United States? 0, right? So this is a much graver daily problem in most of the world than it is in the West and in the United States.
Okay, let's take another short break. When we come back, Ben, I'd like to talk about your experience with Ed Snowden.
Sure.
From a lawyer's point of curiosity,
Yeah.
We'll be right back. That's Ben Wizner, and we're talking to a consummate civil rights litigator. That's how I style the show.
Thanks.
Be right back.
Aloha! Hello, my name is Patrick Bratton. I'm host of Global Connections here at ThinkTech Hawaii. We broadcast live every Thursday at 1 p.m. We bring Hawaii to the world and the world to Hawaii, talking about international events and various things of interest to the audience. Please join me. I look forward to talking with you and having you get to meet some of my guests. Aloha.
Aloha! You can join the Hawaii Farmer Series every Thursday from 4 to 5 on ThinkTech.
And I'm your co-host, Matthew Johnson, here with Justine Espiritu.
And we are so thankful to have this show to use as a forum to get to know all the movers and shakers in agriculture in Hawaii and hear kind of their background and history, as well as
their perspective on what they're doing and also the future for agriculture in Hawaii.
So join us every Thursday. You can tweet in your own comments and suggestions and be a part of the conversation at ThinkTechHigh, and we hope to see you every single Thursday.
Okay, Ben, this is probably the most exciting part for a lawyer to talk with you. So, how did you get this client? How do you get clients like this?
Well, this is an interesting story, actually. You know, Snowden likes to joke that he knew who I was before I knew who he was, but of course he's an NSA spy, so that has a creepy undertone to it. But what he means is just that he was obviously watching the ACLU's work over the years, and part of his motivation for coming forward was that the courts were throwing out our cases instead of considering them. But the way that I became connected to Snowden was that the journalists whom he chose to provide the information to are all people who I know well. In particular, Glenn Greenwald and Laura Poitras, who are the ones who traveled to Hong Kong. Many of your viewers will have seen the documentary Citizen 4.
Sure.
When the camera is on for those encounters. Yeah. And so it was Glenn Greenwald and Laura Poitras who said to Snowden and said to me, you two should get in contact. He needs a lawyer. It should be the ACLU. And so they made the introduction. I actually was here in Hawaii the 4th of July weekend in 2013 when I first connected electronically with Edward Snowden, ironically, because he had been in Hawaii just a month and a half earlier before he left.
Well, he did his work just right down the block, you know.
Yeah, well, I don't know
yards from where we are sitting right
I don't know
now.
about that. I know that, you know, the NSA has a big underground facility here. Obviously, its proximity to China and North Korea it makes this a valuable listening post, and that's where he went to work every day.
Yeah, yeah. Okay, so he contacts you. Now you're involved in this global thing. You know, one of the other changes, it's all about dynamics for me, is, you know, practicing law, especially this kind of case, is an international experience. You might go anywhere or talk to people anywhere.
It's absolutely true. And in fact, at this time, when I first meet Snowden, he doesn't have asylum anywhere. He's in this transit zone in the Moscow Sheremetyevo airport, staying in a quarantine zone. We didn't know if he would be allowed in there, if he might end up back in the United States, or if he might have to take a chance and try to end up somewhere else in Europe or around the world. So we needed to assemble a team of lawyers that could help him in any contingency, and that involved getting prominent criminal defense lawyers in Washington, D.C. That involved getting human rights and asylum lawyers in Europe. And I was trying to play a coordinating role to try to make sure that we couldn't be taken entirely by surprise. But the most important thing to remember about Snowden and lawyers is that he had to make all of his most important decisions without speaking to one. He didn't have any advice of counsel when he was deciding what to take, where to go. If he had gone to a lawyer before he went to Hong Kong, it's not clear what that lawyer's obligation would have been at that time, and he didn't want to create any possibility that anybody else could be called a co-conspirator.
He's a very smart guy.
He wanted it all to be on his own shoulders and not on anybody else's. He is a very smart guy.
You're referring to the rule that if a client comes into a lawyer and says, I committed a crime, that's within the privilege. But if he comes in and says, I intend to commit a crime, then it's not within the privilege.
In any event, it could be a very complicated situation. I'm glad that I was not put in that situation here or asked to receive these documents. I think that the way that he chose of going through news organizations like The Guardian and The Washington Post was the best of all possible choices. Let's actually talk about that decision briefly.
Yeah.
You know, Snowden chooses not one, but a couple of news organizations. Glenn Greenwald at the time is working at The Guardian. Bart Gellman is working with Time Magazine and The Washington Post. He didn't want to entrust these decisions to only one news organization, because in the event that that organization could be persuaded by the government to censor itself, as the New York Times was persuaded in 2004 to not publish an important story about NSA surveillance, he wanted there to be some looking over the shoulder, some competition between different news organizations so that they could have a stiffer backbone. And I think that actually worked out very well too.
Yeah, because you knew the government was going to put pressure on it. It does.
They surely did. And the last thing I'll say about Snowden's legal and strategic thinking is that, remember, this is somebody who could have pressed a button and published every one of these documents himself. The number that he actually published remains 0. And he provided the information to journalists, And his instruction to them was, you need to correct for my biases. My experience is limited. I'm 29 years old and I've spent most of my adult life in the intelligence community. You have the experience and the professional judgment to decide what's in the public interest. You should consult with the government before publishing, but he left it up to the journalist to decide what the public would actually see. And that was
for damage to the country.
And public interest.
And the public interest.
And the public interest to decide whether this is information that the public in a democracy should have. He didn't want that decision to be on his shoulders alone. He wanted to put that decision in the hands of people who had experience. And remember, the Constitution mentions freedom of the press in the First Amendment. So this is a role that the framers envisioned that the press would play.
So they were operating within the notion of freedom of the press. But, in terms of understanding the legalities involved, wouldn't a lawyer have been useful? I know there are issues of conduct and all that, but wouldn't it have been helpful to have a lawyer involved in that?
It depends. I think 99 lawyers out of 100 would have said, don't do it.
Sure.
Because there's no legal advice that somebody could have given to him that would have mitigated his criminal exposure once he made the decision that he was going to provide the most secret documents the government had to journalists.
Yeah.
At that point, he's operating in basically a strict liability criminal regime. There is no defense. And this is why he's not here standing trial. This is why he and I are in the court of public opinion rather than in a federal court in the United States, because under the Espionage Act, under which he's being charged, the fact that the first program that he revealed was deemed illegal by a federal court and ended by a Congress is completely irrelevant. Whether the information was properly classified, totally irrelevant. None of these things come up. The only question for the judge and jury is something that he's already admitted. Did you provide this information to someone who is not authorized to receive it? Well, he did. And so there is no trial.
Case is made.
Case is closed, and these are profoundly serious felonies, and he could be looking at a sentence of hundreds of years for what he's already admitted that he did.
Right, and there are those people in the country that would call for that. They would,
and
they
worse.
would be demanding his head.
And worse.
Head, yeah. So a dangerous business. Now, the last thing I saw was earlier this year, there were there was a proposal, and I'm not sure what the answer was, that he would come back and he would stand trial under those charges, but only if he could be guaranteed a fair trial. And he has Russian counsel. You must know all about that.
Yeah, I think that the lawyer in Russia who has helped him with his asylum and legal status there sometimes makes statements that get misinterpreted by the U.S. press. It's not a secret that his American lawyers have been in contact with the American government about possible non-trial dispositions, what we might call plea bargains. If there had been a meeting of the minds about what the appropriate outcome was, then we would have negotiated a solution. But obviously there is some distance between what we think is the appropriate outcome and what the government does. I think the idea that he would be put on trial under some regime other than the Espionage Act is fanciful. It hasn't ever been proposed by the government or discussed. I think the only way that he would come back at this point is with an agreement in place with the government about what the outcome should be.
That would be smart.
Yeah.
Yeah, but it reminds me of that cooling off period that we talked about at the very beginning, where you have fear, and you have the pendulum swings, and it takes a little while to swing back. And right now, I think the country is still in the middle of that, indeterminate war and terror, and they're indeterminately angry at him. It's not likely to soften in the near term, and it's not likely, to resolve. I mean, do you agree? It's
Maybe
going to
not
take
in the
a while
near term.
to
I
do
mean,
this.
if you will remember this, but I can only read about it. But the way that Daniel Ellsberg was described in 1971 by many people in the government and the press was in terms that are much more vile than anything that's been said about Edward Snowden. He was accused by the Nixon administration of having dropped off the Pentagon Papers at the Soviet embassy in D.C. Crazy accusations were being made. Now, 40-something years later, he's been sanctified. Daniel Ellsberg and I were involved in a debate with James Woolsey, a former CIA director who said Snowden should be hanged. And James Woolsey said, Daniel Ellsberg, I think you're a hero. So history is pretty kind to whistleblowers. We do public opinion research about the views of Americans towards Snowden, and the younger you get, the more positive those views are. So I expect that history will be kind to him, and he will be viewed as somebody who, out of a sense of patriotism, tried to help our democracy, tried to revitalize democratic oversight, not somebody who did harm.
Yeah, and that means that the pendulum might not take that long to come back to a balance where the government softens on its position in this.
I hope it won't be 40 years, but I'll say in other parts of the
like Jonathan
world,
Pollard.
there has been huge progress. The European Parliament, which is the body that represents all the European countries, a majority of the European Parliament voted to call on all European member states not to extradite Edward Snowden. Now, that's not binding because the individual countries have to decide for themselves what they're going to do, but that's fairly extraordinary, that you had the biggest parliament in the world vote essentially to uphold Snowden's whistleblower status. I think the fact that the journalists who were involved in reporting these stories have won the Pulitzer Prize, that the movie that was made about it has won an Academy Award, that Snowden is being nominated for honorary degrees around the world, that he was a finalist, according to the media, for the Nobel Peace Prize in 2014. All these things are moving us closer to a time when it will be possible for him to come back here and not face serious punishment as a felon.
It's the court of public opinion, another dynamic that we may have not seen quite this way before, where people rise up and they create, I hate to say, a kind of precedent, a kind of change in the law, or at least the governmental actions in the matter.
I think that's right. I think that even judges who are supposed to be insulated from politics are not immune to the public mood in these kinds of circumstances. And so, I do think there will come a time where the idea of prosecuting Snowden seems like an absurdity to most people. We're not there yet in this country, I acknowledge that, but that certainly already is the prevailing view in most of the rest of the world towards him.
But everything seems to be moving to a time when government secrets, maybe they shouldn't be so secret. Maybe we can have a sort of a global community of information where we don't pick at citizen information, and we don't keep government information secret.
I think there's still a place for secrecy and confidentiality. I think that anybody who has been around the U.S. systems would say that the problem of overclassification is rampant, that at least half and probably more like 90% of what is classified should never be classified in the first place. I would not argue the radical position that the government shouldn't be able to protect the identities of its covert agents or people in other governments who are helping us out, or troop movements where those are not otherwise known through other technology. I do think that there's still information that the government legitimately can withhold temporarily, at least, not forever, like it does. But the problem is that it's gotten wildly out of balance.
When I was in the service, you hardly knew anybody who had secret and above. Now, 5 million people.
In order to do your job in government, you need to do security clearance. Now, think about what that also does. If you have the set of skills for which you can get one of those jobs, you can't be employed unless you have a security clearance. You don't need an Espionage Act. People are afraid to talk because if the government yanks their security clearance, they're going to lose their livelihood, they're going to lose their community, their friends, their family. It's really a kind of government-wide code of silence. And it's why programs like the NSA's mass surveillance program can develop over years with nobody saying anything about it. Think about how many people knew about this before one of them came forward.
Yeah, and then the Star Chamber. So, is this going to happen again? Will there be another Snowden?
Well, yeah, I think that it's fair to say that there are many more leakers than have come forward and publicly identified themselves. So there has been information that has come to light even since Mr. Snowden provided his information to the journalists. So another whistleblower has come forward to give new information about the no-fly list and about the government's targeted killing program, its drone program. Yes, I think this is the new normal. Is that it's gotten easier and it's going to get more frequent for people to, at enormous personal risk, share information with the media and the public.
Yeah, so 15 years ago, one would not have imagined all the business you're going to get in your career.
I don't think we call it business. Yeah, certainly no one's paying me. Yeah,
it's great. I think you're doing a great service for the country, Ben. And thank you very much for appearing on our show talking about it.
Thanks for a great conversation.
Yeah, thank you.
Take care.
Aloha.